believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce?
All right, everyone, get ready, because this isn't just another courtroom moment. This is a man who walked into the Michigan Court of Appeals armed, not with legal precedent or solid evidence, but with sovereign citizen rhetoric and a determination to escape responsibility. And this wasn't about some right-to-travel fantasy. This case was about child support, not freedom, accountability. From a second, he introduced himself as the executive and beneficiary of the trust of his legal persona. It was obvious this was heading into deep legal confusion. The judges gave him time. They gave him patience. What followed was a clear demonstration of how badly the law can be misunderstood.
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people who just represent themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent of any contract with the state or Title 4D agency to give away my biological and genetic material.
He insisted he was appearing by special divine appearance, not submitting to jurisdiction, because in sovereign logic, terminology is treated like magic. But here's the reality. He was the one who filed the appeal. He voluntarily brought himself before the court, then immediately questioned its authority over him. The judges reminded him this wasn't trial court chaos. This was structured appellate review. Still, he pressed on, asking whether this was a constitutional court, as if the answer might somehow erase his obligations. The panel calmly explained their authority comes directly from Michigan's constitution. That should have settled it. Instead, he doubled down, reframing the courtroom as some kind of maritime or common law battlefield.
The case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court, or in this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked if this is a constitutional court. The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirement. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
This is where tension increased. He argued the court lacked both personal and statutory jurisdiction, despite being the one who filed the appeal. The judge's clarified jurisdiction was firmly grounded in state and federal law. But rather than addressing the core issue, paternity and child support, he shifted focus. He claimed motions were ignored, cited federal rules, default judgments, and civil rights cases like Haynes versus Kerner. He suggested that because he was self-represented, the court owed him extraordinary leniency. Leniency, however, isn't immunity. Courts don't hand out victories because someone misapplies case law. Legal arguments require substance, and substance was noticeably missing.
And it's also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
Then came the constitutional argument. He claimed being ordered to submit to a paternity test violated his Fourth Amendment rights, calling DNA collection an unlawful search and seizure. He even referenced Manel versus Department of Social Services, framing child support enforcement as some constitutional conspiracy. But Michigan statute clearly authorizes genetic testing in paternity disputes. This isn't secret experimentation, it's standard legal procedure. Yet he portrayed it as an invasion of sacred biological property, something requiring warrants and promissory notes. In his narrative, the state offering to cover testing costs wasn't assistance, it was coercion.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a...
Then the performance turned almost theatrical. He began listing Dun and Bradstreet numbers as if exposing hidden corporate identities. Kent County, the Friend of the Court, even the state of Michigan. According to him, they were all businesses, meaning he could simply refuse to contract with them. He compared the court system to McDonald's, arguing that just as no one can force him to buy a burger, no one could force him into legal proceedings without consent. But courts aren't fast food franchises. Government authority doesn't rely on voluntary participation. You don't opt out of child support the way you skip lunch.
Living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for, it incentivizes them to collect more.
He escalated further, claiming federal incentive payments under the Social Security Act proved the state had a financial motive. In his view, child support enforcement was about profit, not children. That argument collapses quickly. The state doesn't purchase parental debt. It ensures children receive financial support from their parents. There's no hidden collection scheme. Still, he insisted no common law crime existed, no injured party could be named, and the entire process was contractual fiction. Motion after motion demanded proof of jurisdiction, proof of contract, proof of injury, while ignoring the simple fact that paternity and parental responsibility are governed by statute, not personal consent theory.
The argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically it's evidence. They didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to dismiss this with...
As time expired, the judges remained composed. They reminded him appellate courts rely primarily on written briefs. His filings had been reviewed. Research attorneys had examined the arguments. A written opinion would follow. But with seconds left, he demanded dismissal, insisting the government must prove its case beyond a reasonable doubt. There was one critical flaw. This wasn't criminal court. It was civil. The burden of proof he kept invoking didn't apply the way he believed. When he asked for dismissal without prejudice, the judge responded with calm finality. No. Next case. And just like that, it ended. A man entered a constitutional court believing terminology could override statute, that consent could erase obligation, and that corporate registration numbers could dissolve parental duty. But courts operate on codified law, not internet ideology. Within weeks, a written opinion would likely confirm what the exchange already made clear. DNA testing in paternity cases is lawful. Child support is not optional. This wasn't a case about freedom. It was about responsibility. And when responsibility enters the courtroom, scripted theories don't survive.